Over here, yes. So that's just one aspect. Now, can we just start looking at the sections? The first section that I would actually talk about is section 2, which is the definition, and 2.1c defines the word commercial dispute. Now, this is of great relevance because if the dispute is not a commercial dispute, you don't go under the Commercial Courts Act. Now, interestingly, it reads as saying commercial dispute means a dispute arising out of, and then gives all of those separate categories. In that sense, there are a lot of categories. The Supreme Court has one of it includes agreements related to I think one of it includes agreements relating to immovable property used exclusively in trade or commerce. Now, the Supreme Court was in Ambalal Sarabhai was looking at this specific clause. The idea over here was that there was a mortgage deed in respect of a property that was to be constructed and would be used for a commercial purpose, and it was filed as a commercial suit. It was argued that's why this comes under the Commercial Courts Act. The Supreme Court said no, the definition must be strictly construed. The idea also is, and this is something that should be kept in mind, because once you go down the commercial courts road, a lot of other aspects change in disposal of the suit. So it has to be strictly construed. Only if it is a commercial dispute, it comes under that. Now, what happens very often is we look at aspects relating to money and we say, oh, okay, this is for repayment of a loan, so it's a commercial dispute. But now the Bombay High Court has also looked at this in Glasswood Realty, where it says a friendly loan or a hand loan or a one-time loan. That's not necessarily a business. That's not necessarily commerce. So that would not be a commercial dispute. So just because you say, oh, this involves repayment of money, that doesn't necessarily make it a commercial dispute. Construction contracts, redevelopment. One way to look at it is just because it's redevelopment, it doesn't mean it's a commercial industry. But there is also something over here which says construction and infrastructure contracts. Can it come under construction contracts? Possibly. There is a judgment of the Bombay High Court in respect of construction contracts, not specifically redevelopment, but it is arguable that it may apply. The point I'm trying to make is that it is very relevant to see what exactly the dispute is at the beginning and to see whether you come under commercial dispute. Fine. Now you've decided that this is a commercial dispute. You want to file your suit. What do you then do? You have to first go straight away to section 12A, which deals with pre-institution mediation and settlement. Now, suits that are to be filed as commercial suits may require urgent relief, or they may require, well, they may not really require any urgent relief. Section 12A provides that if you require urgent relief, then of course you can file your suit straight away in court and you file your interim application and you seek your injunctions. However, if there is no urgency, then you have to institute mediation prior to institution of the suit. And that was, well, there was some, people were not very sure whether that was directory or mandatory, but now the Bombay High Court has held, I think in Deepak Raheja versus Ganga Taro Vazirani, I think Justice Jamdar, the division bench is held that it is mandatory. They recognize that there are two different suits. Of course, if you require urgent relief, then you can't be expected to go spend some time in mediation. The other party may not cooperate and you lose out. That's not the case. You can then go straight away to court. But if there is no urgency, then the idea behind this section and this act is to try and resolve it by mediation. So you must go. It is mandatory. In this spirit, they have also they have formulated rules which are called the Commercial Courts Pre-Institution Mediation and Settlement Rules, which provide for aspects on how the mediation is to move forward. Well, then you file your suit. Let's go straight away. Jurisdiction, I think it's 3 lakhs from 3 lakhs to 1 crore goes to the commercial courts. From above 1 crore goes to the commercial division of our High Court. Section 8, bar against revision application of petition against an interlocutory order. Section 8 is very clear. It says, notwithstanding anything contained in any other law for the time being in force. It's very wide. No civil revision application or petition shall be entertained against any interlocutory order of a commercial court, subject to the provisions of Section 30. Idea being that if you have an interim order, that interim order cannot be challenged unless that order can be challenged in appeal under Section 13 of the Commercial Courts Act. We'll come to Section 13 just after this, which basically means no revision application, which means that the idea that you could file an appeal under the letters patent on the ground that it was a judgment as interpreted by Shah Babulal Khimji, that may also not be available. You can only file an appeal if it is appealable under Order 43 of the Code of Civil Procedure, and that or appeal under Order 43 we will get to, which is permitted under Section 30. Then Section 10 speaks of jurisdiction in respect of arbitration matters. This again depends on what the specified value of the dispute is. Also, it depends on whether it's an international commercial arbitration, in which case it will go to High Court. And even otherwise, it will come to High Court. If it's outside the original jurisdiction and if it's of lower value, then it will go to the Commercial Court. Then there is Section 12, which speaks of how specific value is to be determined. There's not much that really needs to be said about this, except you calculate the value on the basis of what is provided in the section. Now, Section 13. Section 13 speaks of, or rather permits, appeals from decrees of commercial courts and commercial divisions. It is, again, the idea behind this is minimal wastage of time in filing appeals. You can't have a litigant who's just trying to avoid complying with orders. At the same time, you can't have litigants who are adopting frivolous, vexatious defenses in commercial suits and then filing appeals after appeals against orders. So Section 13 says any person aggrieved by the judgment or order of a commercial court below the level of district judge may appeal to the commercial appellate court within a period of 60 days. And any person aggrieved by the judgment or order of a commercial and 1A, any person aggrieved by the judgment or order of a commercial court at the level of district judge exercising original civil jurisdiction may appeal to the commercial appellate division of the High Court within a period of 60 days. An appeal shall lie from such orders that are specifically enumerated under Order 43 as amended by this Act and Section 37. Notwithstanding, this is very relevant, notwithstanding anything contained in any other law for the time being in force or letters patent of a High Court, no appeal shall lie from any order or decree of a commercial division or commercial court otherwise than in accordance with the provisions of this Act. So what does this section really say? This section basically, simply put, says you either you can file an appeal if it's permitted under Order 43 of the CPC, or you can file an appeal if it's permitted under Section 37 of the Arbitration Act. Now, first, let's look at Section 37. Now, Section 37, I mean, we're not going into arbitration, but just one aspect is Section 37 relates to Part 1 of the Act. So orders which are passed in Part 1, which are appealable under Section 37, those can be appealed. However, orders which may be even passed under Part 2, which, like, for example, look at Section 50 of the Arbitration Act. Now, that is not appealable under 37. Consequently, that would not be appealable under the Commercial Courts Act. And this is what the Supreme Court looked at in Kandla Export Corporation versus OCI Corporation. They also looked at, well, not exactly the same. Let's first proceed with that. That was an order passed under Section 50. Then it was said that, sorry, there is no appeal that lies. So you can't go file an appeal under, because it doesn't lie under the Arbitration Act, you can't file under Section 30 and the appeal is not maintainable. There were a few judgments of the Bombay High Court earlier which said, while those appeals may not be maintainable, but you can file an appeal in view of letters patent and the judgment. That law has also been set aside. And now Bombay High Court has also been taking the view that you cannot file an appeal if those appeals are not permitted under 43 or 37. So, for example, Shailendra Bhadoria versus Matrix Partners is a Bombay judgment. Another is Kakade Construction versus Vista. they were proceedings relating to execution of an arbitral award. Idea being that those orders are not appealable. If they are not appealable, then of course you can't file an appeal under 30, and then it stays, the order stays, and it cannot be challenged. So this, I think, is very relevant because it really explains the intent behind this section and the fact that you cannot just file appeal after appeal saying, oh, my right has been affected. There are very limited grounds on which you can file it. Now, another aspect is section 13(1)(a) says an appeal has to be filed within 60 days. If you look at the Limitation Act, I think Article 113 and 116, I'm not sure. But one article says that if it's an appeal intra-court, then it's 30 days from single judge to division bench. Otherwise, if it's from the city civil court, it's 90 days. So the question was, do you go as per 60 days of under the Commercial Courts Act or the 30 or 90? And the Supreme Court has now held in Borse Brothers that you have to go under 60 days, which is section 13(1)(a) of the Commercial Courts Act, not under the regular Limitation Act. Another aspect which comes back to, in that sense, part 1 and part 2 of the Arbitration Act and 37. So we mentioned that if an order is appealable under 37, you can file an appeal under section 13 of the Commercial Courts Act. But in BGS Soma, there was an order passed returning a petition under 34 to the correct court for presentation, like return of claim. That, it was held, is not an appealable order. Because that was not an appealable order, again, under 37, there was no appeal that was permitted. But for example, if you are seeking to amend your grounds under a 34, the Supreme Court has said that rejecting an amendment to the grounds is also appealable under 37. So in that case, I would think that that again would be appealable under 30. So you have to look at whether it's appealable under 37 or 40, as the case may be. I guess the rest is transfer of pending cases. I assume most suits have already been transferred. Amendments to the CPC and its application to commercial disputes. That's section 16. It says, which we've already discussed, provisions of the CPC shall, in their application to any suit in respect of a commercial dispute of a specified value, stand amended in the manner as specified in the schedule. The schedule to this act provides the amendments to the orders of the court. We'll go to those amendments shortly. Now that is the act. If we can get to the schedule, the first aspect, or rather the first amendment in the schedule, is substitution of section 35 of the Code of Civil Procedure. Now 35 of the Code of Civil Procedure provides for costs. The law under the old act or under the CPC as it stood was costs have to be reasonable. And beyond that, there were limitations. However, the amendment significantly widens the scope of the court to award costs. This is very similar to 31A of the Arbitration Act. The idea being that you want to discourage frivolous litigation, frivolous commercial litigation. And the court now has the discretion to determine whether costs are payable. Costs would include fees and expenses of witnesses, legal fees, any other expenses. The general rule is that the unsuccessful party must pay. If the court wants to deviate from that rule, it must explain why. And they can take into consideration a host of factors. Now, this is practically relevant because our courts have been awarding costs. And this could go both ways. I mean, you could have a defendant who is not really, who has been chasing some sort of frivolous defense when he is definitely liable to pay money. Or it may be a plaintiff who has instituted a frivolous suit. Costs are payable regardless if the court is of the opinion, unless the court may say why it is not of that opinion. Now, let's get to the amendments to the orders. The law as it stood was that the Bombay High Court rules prevailed over the Code of Civil Procedure. Now with the Commercial Courts Act, the law is that the Commercial Courts Act prevails over the Bombay High Court rules. The well, one aspect that does come in when you're looking at whether you go with the Bombay High Court rules or whether you go with the Code of Civil Procedure or the Commercial Courts Act is the service of summons. So under our High Court rules, summons were served without a plaint. And under the CPC, summons are to be served with a plaint. Now, as you all know that, and as we had discussed, that you can have very drastic changes and consequences if you don't comply with the timeline provided. So, for example, if the defendant doesn't file his written statement in time, his right is forfeited. But to file his written statement in time, the summons needs to be served correctly. And the Bombay High Court, this is, I think, Atlanta Limited versus Metso India, held that if the summons is served as per the Bombay High Court rules without the plaint, that is not correct service for the purpose of the Commercial Courts Act. So, though it may be a commercial dispute, since the summons were not served as per the Act, the 120-day time limit would not be triggered and the consequences would not necessarily follow. Now, another aspect or another amendment which becomes significant is the substitution of Order 11 in the Code of Civil Procedure. Order 11 provides for disclosure, discovery, and inspection of documents in suits before the commercial division of a high court or a commercial court. A very thorough order in that sense. It's quite exhaustive. The idea behind this is that when a plaintiff files a suit, especially a commercial dispute, he has to produce all documents in his possession or in his custody which relate to the matter of the suit. We used to say, I crave leave. I don't know how far that is valid, because the Supreme Court in Sudhir Kumar has recently also interpreted Order 11 and has said that the idea behind Order 11 is that a plaintiff has to produce everything. Of course, under Order 11, Rule 4, Rule 1, Sub-Rule 4, you can still produce further documents, but then you need leave of the court. And the court will only grant leave if it thinks that there is good reason to grant such leave. So while that judgment did not really relate to someone not producing documents because they crave leave, but I think it is an aspect that we need to consider, that if you have the documents, then why would you not produce it? And then if you are not complying with your provisions of the Commercial Courts Act, is it fair to expect the defendant to then comply with all of the rigid timelines, etc.? Now, the summons have been served, hopefully as per the Commercial Courts Act. The written statement has been filed. Order 5, Rule 1 has been amended. One second. Yes. Order 5, Rule 1 has been amended, that where the defendant fails to file the written statement within the period of 30 days, he should be allowed to file the written statement on such other days as may be specified by the court for reasons to be recorded in writing, but which shall not be later than 120 days from service of summons. The law is quite well settled in this regard by the Supreme Court as well as by our court. The idea being that if you don't file your written statement, or if the defendant doesn't file his written statement within 120 days, his right to file his written statement is forfeited. The Supreme Court held so in SCG contracts. The Bombay High Court held similarly in Axis Bank versus Meera Gehani. Now, let's look at a transferred suit. That is a suit that was initially filed as a regular suit because the Commercial Courts Act was not enacted. And then under 15(4), the commercial division or commercial court, as the case may be, may hold case management hearings in respect of such transferred suit or application in order to prescribe new timelines or issue such further directions as may be necessary, provided that the proviso to subrule 1 of Rule 1 of Order 5, which is the 120-day period, shall not apply to such transferred suit or application, and the court may, in its discretion, prescribe a new time period within which the written statement shall be filed. Now, this is very relevant because our court has held in, I think, Colonial Life Insurance Company Limited versus Reliance General Insurance Company, that if it's a transferred suit, then the timeline has to be decided by the court, and the mandatory timeline of 120 days does not apply. Now, there was another matter, again, Bombay High Court, One Square Investments Limited versus Capri UK Investments Limited. In this matter, the defendant's right to file written statement, in that sense, what had happened was a prothonotary, it was a transferred suit, and then the prothonotary passed an order transferring the suit to the list of undefended suits, granted 4 weeks time to file written statement under the Bombay High Court rules. The court over here held that Rule 90 of the High Court rules will not apply to commercial disputes. In case of a transfer of pending suits, the prothonotary cannot pass an order. It is the court that has to pass the order. That is in keeping with section 15(4) and the other judgment. And that's why the 120-day timeline does not trigger. So that is something else that needs to be in mind, that if it's a transferred suit, the 120-day timeline doesn't necessarily apply. Of course, if the court gives directions to file written statement within 120 days, then of course, those are the directions. I think another aspect of significant relevance, and it's in a novel aspect of the commercial court, is the introduction of Order 13A. That is the order relating to summary judgment. Now, summary judgment is a new concept. It's not a summary suit as it is under Order 37. A summary judgment basically means that a party may apply to the court to give a summary judgment either against a plaintiff or defendant. So a defendant may apply to get a judgment against the plaintiff, or the plaintiff may apply to get a judgment against the defendant. If the defendant considers that the plaintiff has no real prospect of succeeding on the claim, or the defendant has no prospect of successfully defending the claim, and there is no compelling reason why the claim should not be disposed of before recording evidence. Now, Rule 2 has a caveat that you have to move for summary judgment prior to the framing of issues. The idea being that once issues are framed, it is unlikely that the suit can be disposed of without recording evidence. But before issues, if you can show the court that there really is no it's frivolous, vexatious litigation, there is no reason why the claim should be granted, or there is no plausible defense at all, and there is no need, in fact, if it's an ex facie case of fraud, or if, for example, everything's on documents, there is no requirement for oral evidence, then the court may, in fact, short circuit the entire matter and just basically say, this is, I'm in that sense of an opinion that there is no prospect of, in this case, there is no prospect of defense or prosecution, and I'm disposing of the case and I'm filing a summary judgment, passing a summary judgment. Now, in a couple of matters, we have also filed applications for summary judgment. They're pending. They would typically require extensive hearing, but the Bombay High Court has in fact passed summary judgment and has appreciated the intent behind Order 13A in a recent judgment. That was Justice Kulabawala, I believe, which was in Jayant Industries versus Indian Tobacco Company. So in the facts of that case, it was held that it was an ex facie fraudulent case that was filed by the plaintiff. It was an abuse of process of court, and then the suit was dismissed. So this, I think, is another order that could be utilized and would definitely assist the court in expeditious disposal of commercial disputes. Order 18 is also amended by the Commercial Courts Act. Well, they permit parties to withdraw affidavits of evidence if deemed necessary without any adverse inference. They also permit the court to control evidence in the sense that they permit the court to redact evidence, to strike out evidence to the extent that the court thinks it should be rejected in its view. So I think those are, according to me, some of the very relevant aspects of the Commercial Courts Act that we deal with day in and day out. Maybe we can now move to the Specific Relief Act. So the Specific Relief Act dates back to 1963. It was amended in 2018. We'll just go through the amendments. The amendments are of great significance, according to me. They also change a lot of the law, according to me. So I'll just read one sentence from the statement and objects and reasons of the 2018 Amendment Act. It is proposed to do away with the wider discretion of courts to grant specific performance and to make specific performance of contract a general rule as exception subject to certain limited grounds. So this is directly contrary to what the earlier view was, that, I mean, of course, it is an equitable relief. The court has discretion to see whether you comply with the provisions of Section 16. We'll get to that. But if you comply with the other provisions of the Specific Relief Act, then the court shall have to grant specific performance, which was not the case earlier. Before this amendment, it was for the court in its discretion to decide if it was a fit case for grant of specific performance, despite despite the plaintiff not being in breach of the contract. Now the 2018 Act amends several provisions. The first amendment is to Section 6. Now, this is not a big amendment. Section 6 is, I assume you all are familiar. It essentially says that a person who's in possession of a property cannot be dispossessed without due process of law, or otherwise than in due course of law. The earlier law was that him or any person claiming through him may file a suit. Now it has been amended to also include any person through whom he has been in possession. So I would think if, for example, a person has been put in possession by an owner of a property and that person has been removed, then it is also arguable that an owner can now file a suit under Section 6. But for the most significant amendment, let's go to Section 10, which is what we just mentioned, which was granting of specific performance is a rule rather than an exception. The specific performance of a contract shall be enforced. Note the word shall, subject to the provisions contained in subsection 2 of Section 11, Section 14, and Section 16. Now, subsection 2 of Section 11 only is not, in that sense, commonly used because it relates very specifically to a contract made by a trustee in exercise of his powers or in breach of trust cannot be specifically enforced, which is quite self-explanatory. Now, the other two limitations to specific performance are Section 14 and Section 16. Let's go to Section 14 first. Section 14 was substituted in entirety. Section 14, prior to amendment, provided contracts which cannot be certain contracts which cannot be specifically enforced, and it went into some details on some of those contracts. This says the following contracts cannot be specifically enforced: where a party has obtained substituted performance under Section 20. So now Section 20 is also a newly amended section. Section 20 says that a plaintiff who is seeking specific performance may also obtain performance from a third party instead of the defendant. And that is substituted performance. In fact, it goes on to say that a plaintiff in such case can also claim compensation. So if he's already obtained performance from a third party, then of course that cannot be enforced. Second is a contract, the performance of which involves the performance of a continuous duty which the court cannot supervise. This was also there in the earlier act. The idea is, of course, like, for example, if you are referring to an agreement that relates to particular construction, some scheme for allotment of houses, decisions that have to be made on a continuous basis. The court cannot supervise things like that. So those are not contracts that can be specifically enforced because it's a continuous duty. C, a contract which is so dependent on personal qualifications of parties that the court cannot enforce specific performance of its material terms. I think this is quite self-explanatory. Contract so as to sing in a club or to paint a painting. I think those were the illustrations from the Contract Act back in those days. Not that that's changed, but essentially that's what it is. And D is a contract which in its nature is determinable. And this still remains. What is a determinable contract? A determinable contract is not a contract which can be terminated because one party is in breach. That anyways can be terminated under the provisions of the Contract Act. A determinable contract is a contract that can be terminated by a party of its own sweet will, is what Bombay High Court says. The idea being that if a contract can be terminated, then you cannot obviously get specific performance of it. Now, if you cannot get specific performance only in these four limited circumstances, then of course there's no question. Otherwise, performance must be granted. Now, 11 we dealt with, 14 we dealt with. The third exception is Section 16. Section 16 of this Specific Performance Act was also amended slightly. It's personal bars to relief. So a specific performance of a contract cannot be granted in favor of a person, again, who has already obtained specific performance of a contract, which is fairly simple. I mean, that is, if the contract is already performed, nothing survives. Who has become incapable of performing or violates any essential term of the contract, which basically means a person in breach of contract cannot be granted specific performance, and who fails to prove that he's been ready and willing. Now, this aspect of readiness and willingness has always been there. Earlier, the law prior to 2018 was you had to aver, which is you had to plead readiness and willingness as well as prove it. Now, the requirement in that sense is only to prove. But of course, I mean, I would think that to prove something, it is always more prudent to plead it first. So you have to plead your readiness and willingness. Now, readiness and willingness obviously depends on the facts of the case. Readiness and willingness has to be continuous. It has to be throughout the contract, throughout the dispute, you have to be able to show to the court that you are ready to perform the contract. There are two explanations. Where a contract involves payment of money, it is not necessary to actually tender the money, but you must prove that you were ready to be able to deposit the money. You must prove that you had the finances. So this is probably a way where the court may think that if it is in its discretion, if it is of the opinion, if the court is of the opinion that it's not prudent to grant specific performance, then it's not bound to do so because it may find against the plaintiff in the aspect of readiness and willingness under Section 16. So in that sense, there are a few exceptions, but once these exceptions have been complied with, once you've been held to be ready and willing, then the court shall grant specific performance is what the amendment says. Another addition to the Specific Relief Act is Section 14A, which provides for appointment of experts by the court. So the court now has the power to engage experts to assist it on specific issues. Section 20 is on substituted performance. We already discussed that. Section 20A is relevant. It provides for special provisions for contract relating to an infrastructure project. This is also a new section. The idea being that if it is an infrastructure project, then of the categories specified in the schedule to the Act, then there can be no injunction levied against such project. Performance will continue either by substituted performance or whatever it may be, but the infrastructure shall not lag behind just in view of a contractual dispute. 20B provides for special courts to try suits under the Specific Relief Act. I don't know if those have been constituted yet. And 20C provides for expeditious disposal of such suits, which is 12 months of disposal. Now, Section 21, which is also of, I must also add one thing. 20A says that you should not, there should be no injunctions passed against infrastructure projects. There is a corresponding change also in section 41, which is HA. Now, section 41 essentially speaks of injunctions that are to be refused. So it also, section 41 HA says because infrastructure projects and injunctions have to be refused, then even in this case, injunctions have to be refused. And then section 21 is the last section of the Specific Relief Act that maybe we can discuss, because that, in that sense, according to me, is a very significant amendment. It says in a suit for specific performance of a contract, the plaintiff may also claim compensation for its breach in addition to such performance. Earlier, the law was it may claim for compensation for its breach either in addition to or in substitution of such performance. So by deleting the words in substitution of, I think the act makes it clear that a plaintiff may also claim compensation in view of delay, and it is not permissible now to be denied compensation only in view of discretion. If the plaintiff establishes delay, establishes cause for compensation, which would be under section 73, pleads that it is liable to be compensated, then it may be granted compensation along with specific performance as well. I guess that is all I had on the Specific Performance Act as well. And yes, I think that's it. If there are any questions.
Okay. So everyone can now one by one unmute and ask questions. Do not all speak together, but otherwise there will be a chaos and clash. So you can switch on our videos, audio, unmute yourself and start asking questions to Mr. Shah. Mr. Shah, thank you. You have always helped the society by sparing your time.
Thank you so much for having me.
So,
happy to do this.
We have 73 participants today. Good number. Could you please provide name of the judgment at
Yes,
Counsel called
I'll
matter regarding serving of summons?
yes, the name of the judgment is Atlanta Limited versus Metso India Private Limited. Let me try and get the citation for you. Mm. 2021 SCC Online, Bombay 1594. Justice Patel.
Have you noted, all of you? Please switch on your. We want to make this interactive, so please unmute yourself and ask questions. Don't type on the chat. Let's have an interactive session. Madhukar Kulkarni, Madhura Kulkarni. Can you please switch, unmute and ask your question? A question is, please give an example of a determinable contract.
Right. So, for example, any commercial contract really that permits you to terminate with maybe even a notice of 30 days will be determined. Could be a franchise agreement, could be a dealership contract, could be really anything that permits you to terminate without any reason.
A leave-in license contract?
Leave-in license contract is determinable. Unless if you look at the lock-in period, then during that period it may not be, but otherwise, yes, I would think that may be determined.
Anyone would like to ask questions from your papers? If anyone has difficulties and wants to ask questions on the entire Commercial Costs Act or the Specific Relief Act.
Sir, I have a question.
Yeah.
In what way exactly would the prayers need to be modified now while we're claiming specific performance? As in where compensation and damages are concerned, what should be the exact language of the prayer clause?
I mean, in terms of exact language, it depends on the facts and what you're praying for. But essentially, the prayer for specific performance remains the same. But you can also add a prayer to claim compensation. So, for example, if I am for a developer and I have filed a counterclaim against a society which, according to me, has terminated the contract or is seeking to, or rather, I'm seeking specific performance, and I'm saying that I have incurred some costs, then I will pray for specific performance, and I'll say I also want the money for the loss that I have suffered in account of the delay caused by them. So
Okay, so
it's just one additional prayer.
correct, but there is no specific language like earlier. The prayer clause was supposed to be drafted in a specific fashion, and if it wasn't in that fashion, the plaintiff would have trouble. So there's nothing like that anymore.
No, no. So the language that was earlier used will continue being used because you're still praying for specific performance.
Okay,
Now
but
you're praying for one thing in addition to specific performance,
okay,
and that is asking for money,
all right. And all the
not in substitution of which
correct.
earlier
So
used
in
to.
the alternative, the prayer that used to be in the alternative will now be in addition to.
Yeah, but there are two aspects here. One is you were seeking specific performance, so you were praying for it. Then you said in the alternative, which meant if you didn't get specific performance, you should get money. That prayer won't go because you may still not get specific performance and you will want money. But now there is a third avenue, which is you get specific performance plus you get money for the loss that you have suffered. So, for example, if you were supposed to, if the other side was supposed to do something, they delayed, you suffered some loss. You are saying, okay, now I'm still ready to perform. I have always been ready to perform, get them to perform. And because of the money I lost because of their delay, you give me that money also. That doesn't mean you don't get specific performance. That means you get specific performance plus that compensation for delay. And then you put your prayer which says, in the alternative, if you don't get, if you don't give me specific performance at all, then give me all of this money, which is the money that I would have made if the contract had been performed. Alternatively, the money I would have saved if I hadn't paid all this money. Now that really depends on, that's like a whole different thing on damages.
All right. Thank you.
Would this amendment be with retrospective effect, or and can anyone take advantage of these amendments while their suits are pending,
According to
or
me,
it will only apply to suits which are filed after the amendment?
so the Supreme Court has not specifically looked at this issue, but the Supreme Court in some recent judgments, and these are matters that have reached the Supreme Court, has said specific performance, granting of specific performance is compulsory under the amendments. So while some may say that this is not procedural law and it can't be retrospective, etc., I think it can be used if the suit is already filed prior to 2008. Because the Supreme Court has said that in matters which have obviously been filed prior to 28.
Right. Thanks. Anyone else? Questions?
Hello, sir. I have a question regarding
Your
the
video.
commercial code.
1 minute. Switch on your video too. Unmute yourself and also switch on your video so you can know who's asking.
Hello, sir.
I
I have a question regarding the Commercial Code Act. So, as far as Section 21 of the Act is concerned, the Act says that the Act will have a overriding effect over any other prevalent laws. And there are exceptions to this, considering Section 10 and Section 16 of the Commercial Code Act. Those relate to the arbitration and CPC. However, as far as IBC Act is concerned, there is a Section 14 which declares a moratorium. So, in this case, which of the Act will prevail? Whether the Section 14 of the IBC will prevail over Commercial Code, or according to Section 21 of the Commercial Code, the Act has an overriding effect and therefore it will prevail over the IBC.
So according to me, Pranav, both operate in different spheres. The Commercial Courts Act will apply only if your suit is permitted to go on. But IBC injuncts your suit from going on because of the moratorium. So if there is a moratorium under IBC, there's no question of the suit proceeding whether under the regular CPC or under the Commercial Courts Act. So the Commercial Courts Act essentially is like the CPC, but it amends it for commercial suits.
All right. Understood. Thank you.
Anyone else? Okay. One more question I had. Can you just, actually, it's not a question. I would
Yeah.
request you to repeat the amendment in section 6. Like you had mentioned that earlier, only the person who had been dispossessed could move the court. Now there is some amendment which allows
Yes.
even a person. So can you just explain it more?
Yes. So Section 6 earlier said if any person is dispossessed without his consent of immovable property, otherwise than in due course of law, he or any person claiming through him may by suit recover possession. So either he could recover, he could file his Section 6 suit, or any person who claimed through him could file a Section 6 suit. Now there is an amendment which adds one more category of person who is entitled to sue, which is if any person is dispossessed without his consent, otherwise than in due course of law, he or any person through whom he has been in possession. So any person who has put the dispossessed person in possession can also now claim specific performance. So according to me, that could also possibly mean, for example, if an owner has put someone in possession and that person has been removed, then the owner can also seek specific performance. Can seek relief under Section 6. And that also, I mean, in any event, if you have the owner seeking relief, then obviously there can be no injunction against an owner. So there is that additional advantage. But that is the amendment, that any person through whom the dispossessed person was in possession can now also seek specific performance.
Right. Thank you. Anyone else wants to ask a question, or should we end today's session? I don't think so. If there are any more questions, I would like to tell everyone that now tomorrow we have our session on the IBC code by Mr. Nirav Shah at 10 a.m. Please everyone join again. Also, I would like to know that these sessions are particularly a kind of a refresher to inform you of the changes in the law. So it is important for you because in exams, normally when there are changes in the law, the examiner will then normally ask questions on that change law. Therefore, you should know this provision. You should ask questions on that, like I have been asking, or others have been asking. It will help you. So even if uh, you have questions, you can either email it to us, or maybe tomorrow be prepared to ask Mr. Nirav Shah about IBC. If you have questions, you can look into your past papers. One more, I think it has come up. Why don't you ask? Why don't you switch on your audio and ask?
Hello.
And ask. Can you switch on your video and unmute yourself and ask the question?
Sir,
Ah.
actually, I wanted to know if a tenant under the Pagri system can for specific performance under Section 6.
I don't know if this comes under this or Rent Act, but honestly, I think I'll have to check and get back to you on this.
Okay, sir.
Because there is a
one minute,
different.
let me answer.
आर्टिकलशिप का वीडियो मैं यहाँ पे बैठ के देख रही हूँ, उन लोगों को डिस्टर्ब नहीं हो इसके, आपको डिस्टर्ब नहीं होगा, मेरा ईयर
Mehnaz, I'll answer this for you. I know about it. You see, the Rent Act suits basically go to the Small Causes Court Act, and they have a specific provision for recovery of rent and for eviction. Also for declaration that you are a tenant. So if a tenant is going there as for a declaration that that person is a tenant, then one has to go to small cause court and seek injunction or restraint order or whatever order, or to put that person back in possession if they have been wrongly dispossessed. Section 6 of the Specific Relief Act is a section which actually permits a person who has no right in the premises also to approach the court if he has been dispossessed without following the process of law. Which means that suppose anybody can be a person, he may be a tenant or anyone else, he may be a trespasser basically. If there is a tenant, then obviously he has to go to Small Causes Court Act under the Rent Act to the Small Causes Court. But if he is a trespasser or he's claiming as a, say, through somebody has got into possession and the landlord is not recognizing him as a tenant, he is an unauthorized person, then if he is dispossessed forcibly, he can go to the district court or the city court and or the high court and seek relief under section 6.
Okay, so sir, basically, if a tenant further gives the premises and legal license, then the second tenant can
Yeah.
seek relief.
Yeah, licensee can kind of seek. Like there are sometimes, agreements which are made, which are not tenancy agreements or license agreements, but they are made, say, for conducting business. And somebody is in possession to conduct a business, and then he is dispossessed by the landlord or something, then that person can always go under the civil court and say, okay, no, I've been dispossessed without following due process of law. One has to, like, if you want to remove a trespasser who has no right, you cannot just throw him out. You cannot take the law in your hands. You have to file a suit against him and take possession. That's what is section 6 really.
Okay,
Correct?
sir, thank you.
Yeah,
Hello?
absolutely.
Anyone else wants to ask a question?
All right.
Okay.
Thank you so much, and wishing everyone all the best in their exams.
Hi, Vyom. I have one question. This is Dhaval here.
Hi, Dhaval.
Can you throw some light on the structure of the Commercial Courts Act? Like Section 3 says there will be a commercial court at district level, and a provisor says there will be a commercial court at a district judge level. So what's the difference between both of them, and basically the entire structure under the Commercial Courts Act vis-a-vis the pecuniary jurisdiction?
So, well, I think when the act was, I assisted the Law Commission in drafting the report that was prior to the act, and at that point of time, the idea was that you will have a different commercial court. You will then have a commercial division, and you'll have a commercial appellate division. Now, commercial court, the judges were supposed to be judges who were very experienced with commercial matters, and they were supposed to be different from the regular courts. But the act, then afterwards, the act was enacted, and the way it is now is that you have your city civil court. You have certain judges who are now commercial. I mean, those judges are hearing commercial matters, and that's considered to be a commercial court. And then that's the similar thing with the High Court, where you have some courts that are now hearing commercial suits, and that's the commercial division, and then the commercial appellate. In terms of jurisdiction, anything that's within the original jurisdiction of Bombay that's above 1 crore goes to the High Court. There are some matters that may not be 1 crore but are still filed in the High Court, so those will continue going to the High Court. If there's anything above 3 lakhs and below 1 crore, that goes to the commercial court in the city civil. If there's anything below 3 lakhs, then it is not a commercial dispute because that's the threshold value under the Commercial Courts Act. So that's the purpose for Bombay, at least.
Right. Thank you. So we'll thank our speaker once again, Mr. Shah.
All right.
very able counsel.
You've been too kind. Thank you. It was a pleasure being here.
So we all tomorrow. Thank you again for being with BILS and helping BILS with this webinars earlier and also now. We'll see you tomorrow. Join in good numbers. Keep your questions ready on IBC. Okay, tomorrow morning is at 10 o'clock, not 11. I know it's a Sunday, but the speaker had requested to have it early, so we have to have it early. We will also have more sessions on more topics. We are soon planning on CPC and then on maybe conveyancing, whatever. As and when we get speakers, we'll keep announcing.
Sir, I just had one question. So in tomorrow's IBC section, even Companies Act 1956 would be covered, or questions related to that can be asked?
I don't know. Companies Act will not be covered in the tomorrow's this thing. We'll have it separate. But in case you have questions, you can ask the speaker if you want to. One or two. I mean, he's again quite experienced and capable solicitor, and I'm sure he can answer your questions on companies law too. If you want to be ready, I don't think so. There is a problem.
Oh, okay, sir. Thank you.
So as this session is recorded, will this be uploaded online to refer it for future?
Yeah.
Okay, thank you.
We will.
Sir, where will the further notices of such webinars be posted? Because I checked the site, but I couldn't find anything. A colleague of mine sent me today's notice, and hence I was able to join.
You are not on the group with Mr. Jani?
No, sir, I don't think so. I am.
Are you an article clerk?
Yes, sir.
Why don't you request someone, one of your friends, to ask Mr. Jani to join you?
Very well, sir. I'll do the same.
Because I don't know, there is some problem with the website, and I am not able to upload it on the website. I don't know what is the technical issue. I've been trying to tell my fellow to do it. Can you access the website? I thought it's not accessible also.
So past papers are available, but the general notices which were earlier there, it is not there on the website.
Yes, sir.
I cannot post it only. That's what is happening. So therefore, I'm like doing it through where, who's your master?
I am joined in Divekar Bhagwat and Company. Miss Gargi Bhagwat is my master.
Okay, so she is not on any of the Indian solicitors groups?
She is. I'll request her to add me to the group.
Yeah. So no, she can then.
Thank you, sir.
I put it on
Inform.
that also, so she can pass it on to you.
Yes. Thank you, sir. I'll then request her only. Thank you. Because I thought maybe it was on the site and I was not able to access it. That's why I was asking.
I'm not able to access the site. So we are going in for a new website which is under construction, and it's going to take time.
Thank you so much.
It's going to be a very, this new website is going to be very interactive kind of thing, where you will be able to register yourself for article clerks online, pay your, amounts online, all that.
All right, sir. Thank you so much.
It will take some time, but we'll do it. In the meanwhile, I'm trying to get this Google Drive links so that, once these are uploaded, you can at least view them.
Yes. Thank you.
Thank you all. See you tomorrow. Thank you, Vyom, again.
Right. Bye. Thank you. Bye. Good luck to everyone.
Have a good weekend.
You too. Bye.